It's on. Okay. We are now streaming on the YouTube live stream pursuant to the request to do so. All right, go ahead, Ms. Young.
Going back to what I believe the question was before we started talking about YouTube, I think the question that the court had asked was to what extent the Civil Practice Act and the Administrative Procedures Act overlap. There's actually no applicability of the Civil Practice Act until you get to the point of initiating a contested case and beginning proceedings with the Office of State Administrative Hearings. Then at that point, as you are going through those proceedings, you can look at the Civil Practice Act if the APA and the OSA regulations don't cover a topic. But for preliminary investigations like this, I believe that the Civil Practice Act does not apply.
So what is the scope of permissible discovery prior to the application of the Civil Practice Act?
Well, it's not discovery, it's an investigation. It's a quasi-criminal investigation.
Then that's a search warrant, not a subpoena.
The commission does not do search warrants.
Yeah, but you have to have probable cause?
You have to have reasonable cause to begin the investigation. Probable cause is determined at the preliminary investigation hearing. You can look at both OCGA 25-1-6 and the commission's rules of procedure, which are at Georgia Comp Regs 189, and I believe it's 0.07, talks about cases that are initiated on the commission's own initiative.
Okay, so
that's the procedure that governs.
So I think you're telling me that prior to a preliminary hearing, let's start. Prior to a contested case, prior to a preliminary hearing, which is where we are, right?
Right.
That the only thing you have to have is, quote, reasonable cause.
Right. And that's, it's basically addressed already in the Court of Appeals opinion that at the investigation stage, the commission is entitled to send administrative subpoenas. They do have to be, they have to have, actually all it has to be is deemed appropriate by the commission's staff.
What page
in the course of an investigation? I'm sorry?
What page are you reading from?
I'm looking at the Court of Appeals opinion and footnote 2. So during the preliminary investigation, if the commission deems it appropriate, it may serve an administrative subpoena to obtain relevant documents or the attendance of a witness. And the court held that under the Georgia's Administrative Procedures Act's power to issue investigative subpoenas, the commission also can issue subpoenas under that authority as well.
What is that, 50-13-13?
50-13-13B.
Okay, so let's just say at least the word relevance is used, correct?
Correct.
And would you deem that to be relevant to the subject of the investigation?
Yes, the subject of the investigation is whether or not the entities engaged in coordination of their campaign-related activities.
Okay.
And so
asking someone for all communication without establishing or stating or in any way conveying a qualifier, even using the word relevant, is acceptable under your argument.
Well, the fact that there are communications in itself indicates the relevance. Because if this is a truly independent committee, why are they having communications with the campaign? Because an independent committee doesn't communicate with a campaign. That's how they keep that separation, and that's how they enable themselves to spend unlimited amounts of money under Citizens United, airing whatever kinds of advertising and spending however much money they want to advocate for that candidate, but it cannot coordinate.
So the law, as I understand it is that an independent committee may have no communication with a campaign.
Well, or if there is, it's hard to think of a situation other than something very innocuous, like, somebody has ended up on a mass mailing list, for example, in which communication might be considered appropriate. We are not hearing anything to suggest that that type of innocuous communication is at issue here.
Okay, thank you.
We know that there are a limited number of responsive documents that the Abrams campaign has identified. And we would suggest that rather than just saying no, at the very least, they be obligated to articulate why they are non-responsive, rather than just, we just trust us, they're irrelevant. Something along the lines of, for example, a privilege type log disclosing what the communications are and why they are not subject to being produced would be more appropriate in this case. From what we're being told, there's certainly not a large enough number of communications for that to require a great deal of effort and time.
And I was going to, you got there before I did, because I was going to ask about a privilege log. That has not been undertaken.
No.
Okay. You would agree with me, Ms. Young, that the fact that you are in this court, the Superior Court, does make you subject to the Uniform Superior Court rules, correct?
Correct.
Okay. All right. Keep going.
With regard to the other organizations, we've received kind of either non-responses or inconsistent responses as to what they do and do not have. We've definitely received no production of anything, nor have we received any meaningful explanation of any communications that they may have that they're not producing. The only substantive allegation that has been made is that as to Fair Count, and I'd like to address that briefly. Fair Count is an organization that's called Fair Count today, but at the time of the campaign was called Third Sector Development. That's an organization that's been around since, I believe, 1998 that Ms. Abrams started as her nonprofit. And New Georgia Project and New Georgia Project Action Fund were originally just operating entities of Third Sector Development. At some point and the Third Sector Fair Count is not clear when this was. They say sometime in late 2017 or early 2018, which is within the scope of the time period that we're looking for communications. They wound down their operations and became dormant. We don't have any details on when that is. Public copies of the Form 990 indicates that during 2018, that organization raised over $400,000. So I don't know how dormant it really was, but
again, hate to interrupt, but had Third Sector Development registered in any way with the commission?
No, they had not. But during
late
2017
where do you get the assertion that you just made that they, quote, raised lots of money?
That may not be in the record, but it's available online in their Form 990. If you Google the name of theirs and put in Form 990, it comes up. That's a tax form that they file.
A nonprofit can fundraise without being subject to your commission.
Sure. I mean, like the Red Cross may not be subject to campaign finances because they're not campaigning. So there are lots of nonprofits that are not subject to the commission. But when you begin to advocate for the election or defeat of a candidate, then you are subject to the commission's requirements if you're taking donations and spending money for that purpose. regardless of what kind of corporate entity is or what you call yourself. So the point that I wanted to make, because it's been asserted that, you know, third sector development has nothing to do with this. They were actually operating and running New Georgia Project up through as late as early 2018 during the Abrams campaign. There's an affidavit in the record from an employee who did not come into her role until after Fair Count was founded. And she says, well, I don't know where any responsive documents could be, but that's not sufficient to say that there were no responsive documents for that organization up to the point of whenever it wound down its New Georgia Project operations in as late as early as 2018. So
was that employee with Fair Count or with
and you'll find that in Fair Count's response to the motion. But if you look at the timing, it's an employee that came in, I believe, in 2019, if I recall correctly. You know, who simply said, well, you know, we're Fair Count now and we don't know where anything is. You know, they changed their name and got a new employee in, and she says that she doesn't know about any communications, but that, you know, if you read the briefs carefully, you'll see the acknowledgement that at least through up to maybe early 2018, they don't give any specific dates, that organization was continuing to operate as they were transitioning, you know, everything over into these new and separate entities. So, you know, in short, we think the commission is entitled to any communications between these groups. It's relevant to their inquiry. It's within the commission's authority and subpoena power. And barring some credible explanation from any of these groups as to how this is actually overly broad or unduly burdensome, or how some kind of a privilege could actually apply when you have organizations that are also telling you that they're separate and not really communicating at all. You know, the explanations aren't making sense, and they should just be ordered to produce whatever the communications are.
Okay, now, Ms. Young, before you finish and I start hearing from other people, and again, believe me, I got questions for everybody. Sure. This is not just peppering you. And I'm trying to articulate the overbreadth issue, because I think you have acknowledged, you have told me that the Civil Practice Act does not apply at this stage. But I believe you have acknowledged that the concept of the investigation begun by the commission itself does have to bear some relevance. So do you acknowledge, or what do you think about a tailored request? Because my day consists of dealing with Rule 26 and Rule 37. And one of the first things we look at is obviously objections of privilege, obviously objections with regard to relevance and overbreadth and so forth. But the first thing we look at is, what do you want? What are you looking for? And I get that your response is going to be, they don't get to call the balls and strikes. But do you?
Well, actually, yes. As long as we can.
Like me, that you have full control and power to act.
I think that. Well, as you know, as is made clear in the regulations, it has to be relevant.
Okay.
It has to be. That's the limitation. Relevance.
Okay. Now, did you put that in your subpoena?
So, what could be more relevant to the issue of coordination than to find out what people were talking about? What are you communicating about? So we ask for communications, because if you're coordinating, you're communicating. We ask for communication.
You understand you're the state, right? This is state action.
Correct.
Okay.
Correct. And please keep in mind that these are entities that are saying they didn't coordinate. So the question becomes, if you're talking, what are you talking about? Because, you know, it stands to reason that it's most likely campaign-related issues. Now, you know, the case might be different if we were hearing, you know, we've got 30,000 emails, they're all junk mail, you know, here's some examples of the types of things that we're talking about. That's not what we're hearing. And when we've been talking with these parties about this, they will not tell us what these communications say. They just say, oh, trust us, they're not relevant. So, you know, when you're talking about creating limitations, if there are going to be any limitations placed on the subpoena, we need to be very careful that it does not give, you know, any of the responding parties the ability to conceal something that is relevant. That is our concern. And given the fact that it does seem that we don't have a large volume of communications at issue, so we don't have any issues of overburden or hardship in that respect, you know, I think that this is probably limited enough, unless, you know, unless the parties can give the court some reason that these communications wouldn't be relevant to a coordination investigation. Because there's nothing more relevant to the issue of coordinating than to try to find out how these people were communicating with each other.
Okay, so you just said, unless the parties can give the court some reason that these communications are not relevant.
Yes, and keep in mind that exculpatory evidence is relevant too.
Asking you, is that what you just said? Because that's what I wrote down.
Yes, and I also, please keep in mind that exculpatory evidence can be relevant too. You know, if there are 19 emails and, you know, all they're about is, you know, did you, you know, see this new restaurant and how great that is? You know, they could produce that to us, and that would be exculpatory evidence that would help the commission determine that, in fact, there wasn't coordination, and then it could conclude its investigation in that regard and focus solely on whether or not they were independent committees.
Okay. Now, and it is the state's position, your commission's position, that no privilege applies here.
Correct. These companies are telling you that they are independent third parties. So what privilege could apply to communications between independent parties?
Well, we could go through some constitutional provisions. Other than the First Amendment, for example, does the Fifth Amendment apply?
Nobody's raised a Fifth Amendment challenge here, Judge.
Okay, well, just go along with me. Does the Fifth Amendment apply? You said a moment ago you're criminal.
This isn't a criminal proceeding, and we're not doing searches and seizures. I mean, Fifth Amendment self-incrimination privilege could apply if anybody wants to, you know, invoke their Fifth Amendment right against self-incrimination.
Didn't you tell me a little while ago you were quasi-criminal?
Correct. And as I said, I mean, you know, if any of the parties felt a need to invoke their Fifth Amendment rights against self-incrimination, that could certainly apply. I don't believe anybody is, but search and seizure cases are not relevant.
Okay. How about the Sixth Amendment, confrontation?
I failed to see how that would apply in this case. You know, for due process standards, in terms of being able to be notified and present evidence and call witnesses, you know, we have a robust structure in the campaign finance laws and the regulations that apply to them to provide for multiple levels of notice and opportunities to be heard.
Well, okay. Okay. Ms. Young, again, please believe me, I'm not just loaded for you. I got lots of questions for everybody. So thanks for such a great job.
Thank you.
And who's next?
Good morning, Your Honor. I will go next on behalf of New Georgia Project and New Georgia Project Action Fund. And for ease of reference, as I did during the first hearing, I'll refer to New Georgia Project as NGP. That's how it's commonly known. And I'll shorten New Georgia Project Action Fund to just refer to it as the Action Fund, but they are two separate organizations.
Okay.
So I want to start by addressing a number of points that Ms. Young made. She first, at some point and at various points throughout her argument, stated that we had not produced anything, there were no communications produced, no records produced at all. And that is simply just incorrect. The reason we are here is because the subpoena is facially overbroad. It violates the First Amendment. It requests any and all communications between the Abrams campaign and these third-party organizations. New Georgia Project and New Georgia Project Action Fund have...
Well, Ms. Branch, let me interrupt you. I believe in, and maybe this will help, because I think maybe if I repeat Ms. Young's argument, we can make sure I got it right. I think Ms. Young is saying those elements of discovery that those of us in the civil world are so accustomed to dealing with, scope of the discovery under Rule 26, objections that can be filed, and the provisions of Rule 37, she's saying they don't apply here. Basically, all you can say is they're not relevant.
And I think there are a number of reasons why that is incorrect.
Why that's what? I'm sorry, we just didn't hear you. Why that's what?
Sorry, why that is incorrect.
Incorrect.
The first is on the mere question about relevance. It is just simply not correct that any communications between the Abrams campaign and third-party entities are essentially deemed relevant to an investigation of coordination. That is just completely incorrect. If you look at case law on the issue of coordination, it is clear that mere association does not amount to coordination.
And give me a case on that. And I'm not, this isn't law school, I'm just saying, because I've read the briefs several times, if you'll just tell me which case you're...
Yeah. If you look at FEC, that's the Federal Election Commission, versus Christian Coalition, and I can give you the site, it's 52 F sub 2nd 45, and it's cited in our briefing.
Okay.
In that case, the FEC took the exact position that the commission takes here. They said that frequent contacts between the third-party organization, which was Christian Coalition, and the campaign staffs of various federal candidates in advance of the third party's spending on express advocacy was sufficient to treat those expenditures as in-kind contributions. And the court absolutely...
Hang on just 1 second. Where'd you... To treat them as what?
As in-kind contributions.
Yeah. Treat them as in-kind contributions. Okay.
And that's a district court for the District of Columbia case. And in that case, the court outright rejected the FEC's position. It said, and I quote, "A corporation's mere announcement to the campaign that it plans to distribute thousands of voter guides in select churches on Sunday before Election Day, even if that information is not yet public, is not enough to be coordination." And this is key. Coordination requires some to and fro between the corporation and the campaign on these subjects. So, Your Honor, it is just simply incorrect that communications between a campaign and a third-party entity amount to per se coordination. There is significant case law on this. And I think I said in a prior hearing, coordination isn't like cooties in the 5th grade. You don't just get it by associating with people. And the reason for that is the First Amendment, right? There are First Amendment protections. You're allowed to associate and engage in speech with other organizations. And the campaign finance laws don't have anything to say about that unless and until you actually engage in coordination or in contributions or expenditures that are regulated and required to be reported to the state.
Well, how would the commission know? I mean, in fairness to these parties, I think, and I don't know if this is the case with New Georgia and with Fair Count, but the Abrams campaign has said, we've given you all of our financial records. Of course, they acknowledge, obviously, that they enjoy a position of being registered and being a campaign. But how would you know? How are you going to prove it? Can you take depositions?
So the one way that you would know, Your Honor, is that we have not been unreasonable at all with the commission in terms of responding to these subpoenas. As I mentioned before,
you're mad at them because they're being general, but you're saying we just haven't done it.
No, Your Honor. We have had conversations with the commission to try to narrow the scope of their subpoena. We have told them in written and oral communications that the request for any and all communications is facially overbroad. We believe it is outside of the scope of the third-party subpoena that they received and that they claim to be investigating pursuant to. And we have asked them to narrow the scope of their subpoena to communications that are relevant to what they claim to be investigating. And they have refused at every turn to do that, which is how we have ended up before you.
Okay.
I do want to address the scope of the commission's investigation, which you had a couple of questions about earlier. And I want to be clear that we have raised many objections related to the scope of the commission's subpoena, their investigation, fair notice, etc. NGP and the Action Fund have never received a formal complaint against them that informs them that the commission is investigating a coordination allegation against them. They have never received notice of an investigation. They have never been given an opportunity to respond. And this is in direct...
Is that required to send out a subpoena?
It is not required to send out a subpoena, but it is required to investigate. And the commission has said
You just said it's not required to send out a subpoena, but it is required to investigate.
So the commission has indicated today, Ms. Young just said, that the commission has initiated its own investigation into coordination between NGP, these other third-party entities, and the Abrams campaign.
Okay, so if we look at 21 dash, and I don't mean to hijack your argument, we'll get right back on track, but if you look at 21-5-6, which is the powers and duties of the commission, the commission is vested with the following powers. And under subparagraph 5, it says to issue subpoenas to compel any person to appear, give sworn testimony, or produce documentary or other evidence. Now, where does it say that prior to issuing a subpoena, they must either file some type of complaint or give your client some type of notice? And I'm really asking, this isn't a gotcha question. Where does it say that?
So I would direct Your Honor to the rules of the commission. So Rule 189-2-.04.
One more time.
189-2-.04. And the title of that rule is Initiation of Investigations by the Commission.
Okay, and what does it say?
It says that the commission may initiate on reasonable belief that probable cause exists an investigation into suspected violations as it deems necessary, which means the commission does have to have probable cause in order to initiate its own investigation.
Okay, does that require them to give you notice?
It does, Your Honor. The
Where?
commission can only investigate pursuant to a third-party complaint or pursuant to its own investigation. In both cases, we are required to be given notice and an opportunity to respond.
Okay, tell me exactly where I find the words "you're entitled to be given notice and an opportunity to respond."
It's going to take me just.
Ms. Giss Lewis says she's got a slide, if that would be helpful.
I do. I have a slide with that statute blown up, Your Honor, if that would be helpful to the court.
Oh, this is Ms. Branch. Do you want her to do that?
Yes, Your Honor.
You want to share screen?
Yes, just give me one moment, Your Honor.
Okay. And is this in the rules and regulations or is this in the statute?
This is in the rules.
Okay.
And Your Honor, I would just add the requirement of probable cause for an investigation initiated by the commission is also contained in the statute. OCGA 2157 says that when the commission is initiating an investigation, it must initiate on probable cause.
Okay.
Give me just 1 second, Your Honor. So I want to make sure that I'm giving you the right thing and not just my Outlook. This down. This down. And I'm sharing the screen. Ms. Branch, this is the rule that you were referencing?
It is.
Okay, I'll go back on mute now.
So this is exactly the rule I referenced earlier, which says that when the commission initiates its own investigation, it needs probable cause. And then the second portion that Ms. Giss-Lewis has highlighted says that the respondent shall be notified by commission staff in writing of the initiation of the investigation and the basis for finding probable cause to open the investigation. I want to be very clear here. NGP and the Action Fund have never received such notice. They've never received any information about being investigated related to coordination. The only thing they've received was a third-party subpoena. And that third-party subpoena was issued pursuant to a complaint that was filed by Charles Wingo against the Abrams campaign. And that complaint, as you pointed out, references only the Blue Enterprises entity. It does not reference NGP or the Action Fund or Fair Count for that matter. You asked earlier about how the commission got to investigate New Georgia Project. And again, that remains unclear. It is not clear how the third-party complaint that was filed by Charles Wingo has morphed into an investigation of NGP for coordination of which they have never received notice. And all we heard earlier was just that Blue Enterprises is closely connected to another group, which is closely connected to another group. And that's how we led to NGP. That simply is not probable cause for investigation. There was mention about sharing of office space, personnel, and parties involved. That was completely vague. We have never received any allegation that office space or personnel have been shared between New Georgia Project and the campaign or any of the other groups. So we simply responded to the third-party subpoena that we received. We produced, in response to that, payroll records. We produced vendor contracts. We produced canvassing scripts. We produced incorporation documents and other corporate documents that were requested. I want to be clear that that subpoena did not request NGP or the Action Fund's bank records. That simply is not at issue in this investigation or in this litigation. It was not requested in the subpoenas that are at issue in this case. The only request that we did not respond to is the request for any and all communications between the campaign and New Georgia Project. And we engaged in significant back and forth with both the commission staff and with Mr. Fuller from the Attorney General's office, who's no longer with the office, but who represented the commission previously in this litigation. As I said, to try to narrow that request for any and all communications, and the commission refused. I also want to be clear that I talked about the notice that NGP has never received, although it was required to be provided notice under the rules. There was a notice of additional allegations that was issued by the commission, and I think that is also in the record. And again, New Georgia Project was not mentioned in that notice either. There were a number of other organizations that were listed. New Georgia Project and the Action Fund were not among them. So we have never received notice. In our view, this is an off-books investigation that the commission has initiated, not pursuant to its own rules. It is just simply on a fishing expedition to investigate Stacey Abrams, and frankly to intimidate my clients and have them operating under a cloud of suspicion, though they have not engaged in coordination with any campaign or with the Abrams campaign during the 2018 cycle. It's just simply not true, though, that we did not comply with the subpoenas. I do want to address the fact that New Georgia Project and the Action Fund are not registered with the commission. And Your Honor, the reason for that is because they are nonprofit organizations. They engage primarily in voter registration and get out the vote efforts that are not tied to any particular candidate. Their mission is simply to engage voters of color, underprivileged voters, to get them out to vote, to get them registered, not necessarily to vote for any particular candidate. They engage in voter registration drives, voter education activities to that end.
Let me ask you a hypothetical question. So let's just take the Action Fund. Let's say that there were several emails between the Action Fund and the Abrams campaign that said, look, we're willing to put up tables, have bottled water, pass out, brochures at your next campaign event. Just let us know what type of help you'd like.
So I can tell you that.
Does that make them subject to the jurisdiction of the commission?
If they spent in excess of $25,000 and excuse me?
How much is they spend?
$25,000 is the threshold to trigger registration or reporting with the commission.
Okay.
If they spent in excess of that threshold and they engaged in communications that contained express advocacy, in other words, vote for or against the candidate, then they would be required to register and report as an independent committee or as a PAC, if they coordinated with the campaign.
So over $25,000 threshold to register as an independent committee or a PAC.
If they
Is that what you just said?
Yes, Your Honor. If they engage in communications, if they spent money, if that $25,000 or more was spent to engage in communications that expressly advocated for or against the particular candidate that they were coordinating with, then they would be required to register and report as it.
Okay, so what's required here? Are we talking hunch? Are we talking relevancy? Are we talking reasonable? I think Ms. Young used the term reasonable at one point. Or are we talking probable cause?
So Your Honor, I think with respect to the request for any and all communications, they need to be at the very least relevant and narrowly tailored under the First Amendment to the subject that the commission is investigating, which they have said is coordination. So, under the First Amendment, it's a qualified privilege, but it operates in this area where there's, a lot of speech, a lot of association between different groups. It applies generally, and to overcome it, communications need a subpoena for communications would need to be issued pursuant to a properly convened investigation, which this was not. And they would need to be narrowly tailored to the subject of that investigation.
Okay, well, Ms. Branch, you just drew the short straw because this is going to be a question for everybody. It is not particularly pertinent at this moment, but it is going to be a question for everybody since it was raised fairly broadly throughout the respondents' pleadings. And that is this question that the commission has allegedly said, whatever we get, subject to an Open Records Act, and it goes public. So the respondents, almost all, if not all, have raised that as a First Amendment chilling effect. Why can this court, and why can't this court, again, you come into the Superior Court, voluntarily or not, you're subject to the Uniform Superior Court rules. I won't speak to the Civil Practice Act, but you're subject to the Superior Court rules. I know that. And why can't I enter a protective order?
I think, Your Honor, that is a very good point, that the commission has essentially conceded that any communications or other documents that we turn over in this investigation could be subject to disclosure under the Open Records Act. But that isn't the only reason why these communications are privileged. It is not simply that these communications and other documents need to be shielded from the public, but as you stated earlier, the First Amendment protects organizations like NGP, the Action Fund, and the campaign from having disclosed their private communications to the state itself. And so a protective order, while it may alleviate the concern about public disclosure, it doesn't alleviate the concern about having to disclose communications that are privileged to a quasi-law enforcement agency that is acting outside of the scope of its investigation.
But raising money for campaigns, asking people to contribute, and then making sure that money is appropriately spent is a state, it is fair subject of regulation by the state. And you deny that? I mean, you're saying that we don't want them to know what we think, and we don't want them to know who we're talking to, and we don't want them to know what we're talking about, and we here is the state. But they get to regulate this activity because you're asking people for money.
Well, so I think I have a couple of responses to that. The first is that the Abrams campaign, and Ms. Giss-Lewis can certainly speak for herself on this, but they have been regulated by the state. They have filed public disclosures and disclosed all of their contributions and expenditures. And I have yet to hear the commission rebut that or take issue with that. Their reports and everything are publicly available. With respect to New Georgia Project and New Georgia Project Action Fund, they simply have not spent money on express advocacy related to the Stacey Abrams campaign. New Georgia Project is a 501c3 nonprofit organization. By law, it is required to engage in nonpartisan activity, voter registration, voter education, those types of nonpartisan activities, and that's what it has done. The Action Fund—
It's that, the Internal Revenue Service?
Correct, the IRS. And both NGP and the Action Fund file 990s. Those are just basically the annual tax returns with the IRS, and they disclose their activity there. So it is not that these organizations are acting under some cover of darkness. They all have disclosure obligations that they have complied with. It is just simply that they have not engaged in express advocacy related to Ms. Abrams' gubernatorial campaign in 2018, and thus we would argue are not within the jurisdiction of the commission. With respect, we are not saying that the commission doesn't have any authority to investigate or to subpoena. That is clear, based on the law. And like I said, we have complied with the subpoenas to the extent they are lawful. But the request for any and all communications and is simply not lawful for the reasons that we've explained. One being that they have not followed their own rules to initiate this investigation against NGP and the Action Fund. And two, they have not overcome the privilege. The scope of the subpoena is simply too broad to overcome the application of the First Amendment privilege, or even to meet a mere relevance standard, Your Honor.
What was that last part?
Or even to meet the mere relevance standard. As I stated earlier, the FEC versus Christian Coalition case is clear on this, that mere association is not enough to create coordination. So Ms. Young said several times that the fact that these organizations were communicating makes them per se relevant to a coordination investigation. That case says the absolute opposite. That's just simply not true.
And that's applicable to this court because it deals with the federal constitutional privilege, which I'm bound to uphold because is that why you're citing that?
That's correct, Your Honor. And because the coordination standard that the Georgia state law has adopted is essentially the same as the federal coordination standard, which is what was applied in that FEC case.
Okay.
And the commission has essentially agreed with that in its briefing.
Agreed with that in its submission, or what did you say? We're having a little trouble, and maybe on our end, Ms. Branch, but
I'm sorry,
some of it is a little muffled.
Oh, I apologize.
Like that, for example. I don't know if it's when you're turning, I don't know if it's when you're turning from the microphone or what it might be, but we're losing the last third of what you say.
Okay. I'll try to speak a little slower, but on the commission's briefing on the motion to compel that we filed in this case, they essentially agree that the Georgia coordination standard is akin to the federal one. And so that's why I think that the FEC versus Christian Coalition case is applicable here, because they were applying that exact same standard.
Anything further?
The last point I would make is just that Ms. Young said that it's essentially the commission has authority to, quote, find out what people are talking about. And I think that is just not the job of the commission. It is not the job of the Georgia Campaign Finance Commission to seek communications that are outside the scope of their authority, just because they're interested in knowing what people are talking about. And in that way, the request for any and all communications. It's facially overbroad. It violates the First Amendment. And it is our position on those grounds that the motion to compel should be denied, Your Honor.
Okay. Thank you so much, Ms. Branch.
Thank you.
Who's next?
I'm happy to go next, Your Honor.
Thank you.
So I would obviously join in the points that Ms. Branch made. And I imagine that you, as you said, are going to have some questions for us as well. But I do want to start out with a point that I do not think is particularly controversial, which is that the Abrams campaign has produced thousands of pages of documents in response to the subpoena that was issued in this matter. The Abrams campaign has been extremely consistent from the time that it first received the subpoena, that it objected to the overbreadth of the subpoena, that it responded in the initial response to the subpoena before the production was even due. We responded to clarify with the executive secretary that the commission is alleging that this complaint is based on that the subpoena is based on the Wingo complaint, and therefore we read the subpoena requests in conjunction with the Wingo complaint. It has been touched on, I believe Your Honor has observed, the Wingo complaint does not make any reference to New Georgia Project, and it does not make any reference to Fair Count. There does not appear to be any nexus between that complaint and the subpoenas that were served. And we made that point, as I said, within a week or so of receiving the subpoena in the first place. So I take exception to Ms. Young's characterization that we didn't do anything other than simply not comply with the subpoena. We did quite a lot. We provided written objections. We had several meet and confer sessions with Secretary Amati and with Mr. Fuller, the former counsel for the commission, in an effort to get them to narrow the scope of what they were requesting. And
now let me ask you a question again.
Yes.
Pardon the interruption, but with regard to the written response, written objections, there are in the record at least for New Georgia Project, and I'm sure you probably got one in here. Wait. There is in the record a letter written, I believe by you, Ms. Giss-Lewis, dated May 31st, 2019. And it is regarding specifically objections and responses to April 26, 2019 subpoena to Abrams campaign, and references a case number. And that specifically is Exhibit 3, I believe, to your response. Now, again, I apologize for not knowing a whole lot about the procedure in front of commissions at this stage, but talk to me about whether does that have to be sworn to? And I think at one point you or someone offered or suggested an affidavit. What's the procedure surrounding that? Because this is a letter response, and that could very well be all that is required. But when do we get into the issue of, well, they just said that. Well, it's different if you say it under oath.
Your Honor, I appreciate you pointing out the May 31st response, which accompanied our initial production. I do want to just make clear for the record, that was not our first response the subpoena. As I said, we reached out within a few days and let Mr. Amati, the executive secretary, know that we had concerns about the scope of the subpoena. To the point of your question, though, we let them know from the beginning that we had these objections and that we had these concerns. And as I said, we had a number of meet and confers, and that was the point at which we asked them whether that would be something that they would be interested in having. Would they be interested in having some sort of an attestation, an affidavit? They did not express any interest in that. I'm not aware, and I'll ask Mr. Sparks to confirm for me, but I'm not aware of any requirement that our objections be accompanied by an affidavit. But certainly during those meet and confers that we had over the course of numerous months, I mean, basically between May and the time of this matter being filed, and I believe it was October or November, we had multiple meetings with them, and they never expressed any interest or need or pointed out that there was any sort of a deficiency in us not providing an affidavit. And certainly if an affidavit had been requested and that was something they were interested in having, that's certainly something we would have been willing to talk to them about. But they never asked for it.
Okay, now Ms. Branch got the question about a protective order. So your short straw is you get the question about, do we need an in-camera production?
Your Honor,
the subset of in-camera, I guarantee you, is going to be a special master.
Let me just say this. I don't think that we need an in-camera. I think really the issue here is whether what the scope of their authority is in order to ask for these documents in the first place, and whether there is a reasonable way to narrow the scope of what they've requested so that it is within their authority. And the reason I say that about the in-camera is I promise you that if the end result of this proceeding is an order from this court saying that a request for any and all communications is fine, the Ethics Commission is going to issue requests for any and all communications to whatever campaigns they decide to in the future. And you and your colleagues on the Superior Court bench are going to be in the position of having to essentially babysit every one of these with an in-camera review.
I think the Court of Appeals has already explained my job to me. And so floodgate arguments, of course, are just that. My question is, if we do get to that point, Ms. Branch addressed it by just saying, we promise. It's not there. And Ms. Young has said, yeah, but we don't believe you. So how do I decide? I mean, if this was the Coca-Cola Corporation suing Federal Express, I would appoint a very lucky special master, and I would send them off for months and years to go through each and every document.
Let me draw a distinction between that hypothetical that you just threw out, Your Honor.
Okay.
If it were Coca-Cola versus some other multinational company, there would be a complaint that explained what the basis of the claims was. We don't have that here. What we have here is essentially the commission saying, trust us, we have a reason for asking for this stuff. They're the ones that are saying, trust us. We are the ones that are entitled to an explanation of the basis for their investigation. Their rules require them to give that to us, and they haven't. And we've sat down with them multiple times, and we've told them that we want to have that and that we want to cooperate if they can tell us what they're looking for. And the response has been, no, we don't have to, and we're not going to. They are the ones who are simply saying, trust us, we're entitled to this. They are the ones that are here seeking to have this court give them the benefit of the doubt, even though they are the party. They are the party that, as Ms. Young said, are acting in a quasi-criminal capacity. And as Your Honor, as a Superior Court judge, is well aware, that means that these rules and this request has to be construed against them. And if I'm allowed to share my screen, Your Honor, I believe
it needs to be construed against them. I mean, if the state seeks information, and again, I raised the specter, and it's nowhere in the authority that I have read, but I raised the issue of a search warrant. And but even a search warrant has to have probable cause attached to it. So I understand that you're saying that if we were in court and one side said, well, we need all this information because these are the allegations of our complaint, I understand that, but you're in court. I mean, you're both in front of a Superior Court judge. And I am hearing both sides say, we don't trust the other side. And that generally can result in an in-camera inspection. I'm through a declarative sentence.
I appreciate that. I appreciate that, Your Honor. Georgia law actually does require that you construe the commission authorizing statute against the commission.
Okay.
I mean, that is actually a fact. I can cite you to Schloff v. Smith, 134 Georgia App 529 at 530, which is a 1975 case, which says the election law is in derogation of the common law and must be strictly construed. And further says, I can also cite you to Georgian Art, et cetera, v. Gwinnett County Board of Tax Assessors, 211 Georgia App 510, which states that the applicable rule of statutory construction is that forfeitures and penalties are not favored, and statutes relating to them must be strictly construed and in a manner as favorable to the person against whom it seeks to be enforced, as is consistent with fair principles of interpretation. So there is certainly a basis for our position that, to the extent that there is any question about the limits of the Ethics Commission's authority with respect to these broad subpoenas, that has to be construed against them and in favor of the respondents.
All right, let me interrupt you just 1 second. Don't anybody go anywhere. This is going to take about 2 minutes. Just give me a moment. All right, Ms. Giss-Lewis, would you like to proceed?
Yes, thank you so much. And I had asked a moment ago if I could share my screen, Your Honor.
Sure.
Thank you. So this is the site that I just gave to the court. This is from the State Ethics Commission versus Moore case. And we have cited to that case pretty extensively in our briefs for that proposition. I also I want to go back to the question that you raised a few moments ago about, the fact that you would send this off to a special master if this were two civil parties. I don't, as I said, you would have an actual complaint that spelled out what the basis of the claims were in that case. But I mean, to extend the court's hypothetical, if Coca-Cola sought from Pepsi all of Pepsi's executives' emails, all of their emails, any and all communications, unrelated to, whatever the basis of that complaint was, you would not need a special master in order to deny that request. You would say exactly what you have said to the state. What do you need it for? What does this request have to do with your claim? And they would be required to answer that. And I haven't heard the state answer that. I haven't heard the state answer any question as to why the request that they've submitted cannot be narrowed in some reasonable way.
Well, I think the response has been they don't have to. I mean, I think there's been a response.
I have not heard, let me correct myself then, Your Honor. I have not heard a citation to any authority that supports that response, that they don't have to. And instead, what we have, as I shared with the court during Ms. Branch's presentation, is we actually do have rules for the commission that require them to provide probable cause, that require them to provide notice of what it is that they are doing. And I don't want to rehash what was covered at the last hearing, but suffice it to say, the response that we have been consistently told is just what Your Honor just said, which is, well, we don't have to. We can ask for whatever we want, and you have to give it to us. There's no basis to say that. They are a creature of statute. Their limit is contained within the authorizing statute. The authorizing statute doesn't give them the right to just say, we get all communications from whatever entities that we choose to get them from. If they are actually focused on coordination, then I think it's appropriate for us to talk about what coordination is and what coordination isn't. And happy to talk about that a little bit if you will allow me to share my screen again.
Sure.
So, pardon me.
While you're doing that, Ms. Gist-Lewis, and I don't, I can't do technology and anything else, but is there any acknowledged limitation by your client to First Amendment privilege?
I'm sorry, Your Honor, you're asking if there's any limitation to the qualified First Amendment privilege?
Yeah, is there any recognized is the word, I think. Is there any recognized limitation to First Amendment insofar as your client is concerned?
That our client is required to provide certain materials as a condition of being a campaign that's run in Georgia. We have reporting requirements. We are required to make certain disclosures on a regular basis, and we did that. We have done that, and there has not been an allegation in this case that we have not done that. I believe what Mr. Fuller actually said at the last hearing is that they don't have any basis to believe that our financial records are not on the up and up, is specifically what he said. But so there, obviously there is some waiver of what would otherwise be a right to privacy with respect to those records as a condition of being a campaign. But the campaign has accepted that. The campaign has complied with that. The issue, and I think Ms. Branch covered this very well, the issue really becomes whether the fact that you are existing as a campaign in Georgia means that you should be able to be compelled to open up all communications, any and all communications that your campaign might have upon receipt of a subpoena from the commission. And I appreciate the court's observation about the protective order, but at the end of the day, the any and all communications issue still raises the chilling effect, still raises the issues of association and speech. And again, I think Ms. Branch covered this very well, but I would say that the limitations that exist on our ability to say that our First Amendment rights have been infringed upon, they are allowed under the statute to request certain things, and they have requested those things. I think if they were able to narrow the scope of what they're asking for in the request for communications so that it was tied into those obligations, those reporting obligations, that would potentially require further analysis about whether or not the First Amendment privilege would apply, but they haven't done that. So I'm sort of being.
Well, let's because that was going to be another question, which is the tailoring or narrowing of the request to communication relevant to the issue of coordination, and then a definition, a strict definition of what coordination is. What's wrong with that?
I don't know that there necessarily is something wrong with that, Your Honor, but they haven't done that. No. And I think this might be a good time for me to go ahead and bring this up, because let's look at a little bit of what coordination is, right? Okay. This is from the Commission's rules. This is from Rule 189-2-.01 subsection.
So give me that again. I'm sorry, give me that again.
And it's at the bottom of the slide. It's very tiny, but it's Rules and Regulations 189-2-.01. Okay. And this is subsection 12. And you see it defines what an independent expenditure is, okay? So a political campaign communication that expressly advocates the election or defeat of a clearly identified candidate that is not made in cooperation, consultation, or concert with, or at the request or suggestion of a candidate or candidate's authorized committee. So that's what an independent expenditure is according to the Commission's own rules. Ms. Branch referenced coordination standard under the federal statutes as well, and this is from 11 CFR 109.2 subsection A. And you will see this is a similar definition. Coordinated means in cooperation, consultation, or concert with, or at the request or suggestion of a candidate's authorized committee or political party committee. So again, we know that there's a definition of what coordination is.
What about a request for communications between the named entities? And I know Mr. Castorp is going to want to argue that fair count that isn't in this, but what about a request that asks for communications between the Abrams campaign, New Georgia project, and the action fund that dealt with this definition? What about that?
I think that there would need to be some additional narrowing, and the reason I say that, and this was touched on a little bit during Ms. Young's presentation, she was talking about these subpoenas being appropriately limited. I would posit that in order for them to be appropriately limited, they need to be limited to the actual subject campaign cycle, which here ended in November of 2018. It would be from May of 2017 until November, I believe it's 18th of 2018, which is when the election ended. So A, B, and Mr. Fuller talked about this during the prior hearing on this motion to compel. Right now, the request is between any and all agents, employees, whoever. So basically, the receptionist can send an email, and that would be something that they would be looking for us to produce under the plain language of the request that they have served.
Yeah, you can narrow it down to people that you know have had no communication. I mean, the receptionist doesn't count.
I'm sorry, Your Honor, I didn't quite get
the receptionist doesn't count.
Well, the issue is it needs to be someone who actually has the authority and the ability to coordinate, to direct conduct, that has that ability. Again, the example that Ms. Young threw out about people emailing about going out to a restaurant, that would be something that would need to be produced under the subpoenas as they are currently written.
Understood.
So, and
we're talking about significantly narrowing the language.
Yes, Your Honor, we do think that is appropriate.
So you want to narrow it though to certain people, and I guarantee you, I can go back to my office right now and tell my judicial assistant, please send an email to my senator that says, I just don't want to be subject to these laws anymore. And is that okay? That it's coming from somebody else, so it's therefore not producible?
Your Honor, our position would be that it's not going to be possible for an intern who's working at the campaign who has a campaign URL email address to direct coordinated activities. But with respect to the hypothetical that you just gave, I'm not sure how that would work. Again, and maybe I need to back up a little bit, because I do want to make,
before you back up, keep that thought. Is the state subject to paying for this?
I'm sorry, is the state subject to
paying for this? Reasonable copying expenses, efforts on behalf of the person standing at the machine, efforts of the person culling through hundreds of thousands of emails. Does the state have to pay for that?
I'm not aware of anything that says that they have to. They certainly have not offered to do that here.
Okay.
And when I said I wanted to back up, I did want to back up, because the hypothetical, here's the issue with the hypothetical that you just posed about you directing your receptionist to do something for you. That presumes that there is some plan ahead of time in order to try to disguise this communication. And I do want to make something really crystal clear, and we covered this in the first hearing. Understand, there is no obligation whatsoever. There has never been an obligation on the part of the campaign to preserve communications. So this request, this request is completely unprecedented to our knowledge. I'm going to share my screen with you again. This is actually from the letter that Mr. Amati, the Executive Secretary for the Ethics Commission, sent me on May 10th, 2019. And he says, you are correct that present law does not require a candidate to maintain correspondences. And I point that out to you because your hypothetical presumes that there's some effort to disguise. There would have been no need for anyone to try to disguise communications with regard to coordination because no one had ever been asked for communications before. And so there wouldn't have been any sort of parameter to try to hide behind in the first place. It essentially, the question presumes that there's some effort for the people who would have the authority to coordinate to go through someone else in order to hide the fact that they had done that. It's speculative, and moreover, there wouldn't have been a reason to do that at the time that any of these communications would have been generated, because no one had ever been asked for that before, and because the campaigns were not required to preserve these communications in the first place. It is pure happenstance, Your Honor. It is pure happenstance that there was the ability for the campaign to retrieve any emails when they received a subpoena for them in 2019. It is pure happenstance that they were able to retrieve anything in order to do a search in the first place, because they were never required to preserve that under the law. And we would submit, and we've argued this in our briefs, that the lack of an express requirement that you preserve these communications strongly suggests that the legislature did not intend for these to be within the scope of what the commission would be automatically entitled to receive without there being some probable cause, without there being some relevance to the investigation, without there being some notice to the party being subpoenaed about what this has to do with the investigation that the commission is conducting in the first place. I know that you have spoken about, the potential for a protective order. And, I understand that to be a matter of each individual court's discretion. I do want to make sure that we're clear that, the potential for harassment of employees when these types of communications are made public, which I understand you're thinking that you might be able to cure that with a protective order, but in terms of the precedent that might be set by enforcing such an overly broad subpoena, and what we would expect the conduct of the commission to be thereafter, which is to continue issuing such overly broad subpoenas, the potential for harassment is huge. And I believe the court is probably aware that in this day and age, once something is subject to an open records request, it can be all over the internet in a matter of hours. If there's no limitation on the content of what is being sought in these communications, then an email someone sends to a friend about a personal matter, a romantic matter, a medical matter, what have you. All of that is potentially subject to public disclosure. And we submit that the way to deal with that is not to conduct in-camera reviews or issue protective orders. The way to deal with that is to tell the commission that if you are saying that you need these documents for purposes of your investigation, you need to tie the requests to whatever it is that you think has been done wrong. You need to tie it specifically to the scope of your own authority under the act, and they have not done that here.
You still there?
I am still here.
Okay.
I'm trying to get myself back to back to Zoom. And I might be a little bit technologically challenged on that. What am I doing wrong?
Still sharing the screen.
There we go.
Mr. Sparks fixed it for me. So I think that is, those are.
Okay, well, let's get down a little bit more to rolling up our sleeves, and certainly I'm going to move on to whoever would like to speak next, and certainly I'm going to get back to Ms. Young. But it seems to me that, again, if the specter of quasi-criminal has been raised, puts it on an entirely different plane. But in terms of the Rule 37, because initially Mr. Fuller, I thought, and I've just read it recently, that Mr. Fuller made the argument that that's what you were doing, that's what the commission was doing, was simply taking advantage of the superior court's ability to compel adherence to a subpoena. But subject to, the fact that she has raised the specter of quasi-criminal, perhaps a different plane, the court's nevertheless interested in exploring without ruling, because I understand both sides want all or nothing, but exploring a narrowing and tailoring that is both protected and perhaps even in camera. And I'm asking you what you want, Ms. Gist-Lewis, because I get that you want me to tell them to go far, far away. But what is 1A?
So I do believe that there is some language that that the respondents believe would be reasonable. And actually it comes from both the commission's briefing, where they have, and Mr. Fuller's argument, where he's sort of been trying to make a more make this look more narrow than it actually is on its face. So if the court would like to hear what respondents think would be a reasonable narrowing, I'm happy to speak to that. Before I do, I do want to make one point that I think is really important. There's been a lot of talk about independent committees here today. There's been a lot of talk about PACs. There's been a lot of talk about all of this. With respect to the requests that were sent to NGP, those requests were not just limited to requests for communications with PACs. And I am gonna pull those up for you, Your Honor, just so that we have them in front of us and we know specifically what it is that we're talking about, that the commission has actually asked for.
Are you talking about the subpoena to the Abrams campaign?
Correct, the subpoena to the Abrams campaign. And the reason I'm talking about it is because in the context of independent committees, et cetera, and I am going to go ahead and share my screen, is because they made these requests for New Georgia Project, Inc. They also made requests for any and all communications with Nikema Williams, who was at that time the vice chair during the campaign time. She was the vice chair of the Democratic Party of Georgia. Of course, she is now Congresswoman Nikema Williams. I have not heard anything, any rationale, any justification for why any communications with Ms. Williams, who herself was running a campaign at that time and who was appearing at the same events as AFG's candidate, why the communications with that co-candidate are something that the commission would be entitled to.
Why would they not be entitled to it?
Pardon me?
Why would they not be entitled to it?
Because in order for there to be going back to what we were discussing previously, in order for there to be a coordinated communication, there needs to be an independent committee. Ms. Williams is not an independent committee. She's a person. And if she individually wants to work with the campaign, if she individually wants to donate to the campaign, if she individually wants to show up at the campaign's events, she's entitled to do that. The campaign is required to disclose her contributions the same way that they would be required to disclose any other individual contributors' contributions. And for that reason, and again, I just did not want this to get lost. I am going to get to your question about the narrowing, Your Honor. For that reason, that part of the request should be struck in its entirety, because they're not entitled to know what the campaign or Ms. Abrams individually might have said to Ms. Williams.
Okay.
So thank you for indulging me on that, Your Honor. I'm going to get us back.
Tell me what you wanted to say, even though that's not what you want. Tell me what you might want it to say.
Yes, let me get my.
So we're talking now about the subpoena to Stacey Abrams and Stacey Abrams for governor.
Correct.
Okay.
So I'm going to, as I said, I'm going to put up I'm going to put up some language that we think would potentially would be reasonable, would meet the aims and intents of discovering if there were communications reflecting coordination, and would be allowable under the First Amendment. So hopefully you're able to see that. We believe that the communications should be limited by time. They should be limited to communications that were created or modified between May 2nd, 2017 and November 17th, 2018, which was the date that the election results were certified. We believe that a proper subpoena would seek only communications exchanged between authorized agents that had decision-making power and therefore had the ability to actually coordinate. And it would be communications using those official entity channels. And this is the most important part. The communications would need to expressly reference electioneering, resource allocation, including contributions or expenditures, or personnel shared among two or more regulated entities during the cycle at issue. Those are suggestions of ways that that the subpoenas that were issued in this case could have been reasonably narrowed. I will.
Let me ask you, so that last one is in the disjunctive. So, okay, or personnel shared or resource allocation. How many of us write emails that say, now, with regard to electioneering? So you're not suggesting that these be put in a processor for a word search that turns up the word electioneering. This is in the disjunctive in the event it does touch on any of these issues.
I apologize, Your Honor. You were going in and out just then. Can you?
Oh, okay. I'm sorry.
What you just said?
Yeah. With regard to this third bullet point, I read this as being in the disjunctive, meaning that it can involve one or any one of these issues: resource allocation, personnel shared, because you're not going to find any emails if you're insisting on those emails saying, and by the way, with regard to electioneering, let's talk about that. That's not going to happen. So you realize that the court is going to construe that as being, again, in the disjunctive.
Correct. So with respect to that third bullet point, I do want to make clear that the narrowing from our perspective, it should meet all three of these bullet point criteria. But with respect to the third bullet point itself, I would agree if it references, electioneering, express advocacy, allocating resources, an independent committee making expenditures on behalf of the campaign or that benefit the campaign, or sharing personnel. And I mentioned the sharing personnel because during our meet and confers, there was some suggestion by Mr. Fuller and Mr. Amati that there was some concern about the possibility that there might have been some shared personnel. So that is something that, that we included in there. We have not seen any evidence of this, but since that is something that they have expressed an interest or a concern about, and because technically that could be construed perhaps as an in-kind contribution, a reasonable narrowing could limit the communications to communications that reference any of these issues that are referenced in bullet point 3.
Now, and you may be getting to another screen. Tell me if you are, but are these communications between the campaign and anybody deal with these subjects?
No. So the communications, what we are talking about is a narrowing of the subpoenas that have been issued.
Right.
Right. So the presumption would be that the narrowing would only go to the subpoenas that have already been issued. It would not expand the scope of the existing subpoenas by opening it up to everybody. But and as I said in bullet point 2, it would need to be between authorized agents with decision-making power. And we believe that this could be reasonable. During our meet and confers, we attempted to suggest to the commission that they should limit in a way that looks like this. I believe in at least one of the briefs that Mr. Fuller submitted, that he might have conceded that the timeline should be shortened to the end of the certification of the results in the election cycle in 2018, rather than through the present, which is what the requests currently say. But we are providing this for the court because the court has expressed an interest in seeing what we would consider to be reasonable. But again, the commission has never expressed any interest in having anything like this from us.
Okay. Okay. Is it time for somebody else?
Give me one moment, Your Honor.
Sure.
So, Your Honor, I believe Ms. Branch covered this very well, but I do want to make sure that I'm on record as stating on behalf of AFG that notwithstanding the fact that we think that there are ways to narrowly tailor this subpoena, we still maintain that the commission has not shown that the communications they are seeking are highly relevant to a properly founded and noticed inquiry. They have not met their burden. They have not met what they were required to do in terms of telling us what is going on here. And Your Honor properly observed, if this were a criminal matter, there would be, you would need to get a warrant. You would need to get a grand jury subpoena. If this were a civil matter under the Civil Practice Act, we would have a complaint. We would have something that spelled out and provided us notice of exactly what it is that they think that they have. At the last hearing, they literally showed up and showed you a bulk mail, an email blast, if you recall. They showed you an email blast and said that was the basis for them believing that there had been some coordination. And and we covered this at the last hearing, public communications are not coordination in any event. But I make that point to say they still have not told us what it is that they think that they have that explains why they're entitled to any of this. And I hope that the court is going to ask them, I mean, what is it that they think that they have? Because we still don't know.
I think what I'm still short on, and I'm sure Ms. Young is going to come back and explain it to me. I think what I'm still short on is what stage are we at and what standard applies? Because there may be a gray area, there may be a crack between that, and you have shown me the rules and regulations, and I have them up on the screen. But there may be a crack, there may be a gray area. I'm sure some appellate court may look at that once more. But the standard, I mean, I can't make this stuff up.
Right.
I mean, there has got to be some appropriate standard to apply, and I'm just still, I gave Ms. Young some choices between hunch and probable cause, and she picked relevancy. And I certainly believe her, unless somebody can cite something else to me.
Well, Your Honor, if the commission's position is that relevancy is the standard, then we need to know what the investigation is in order. You also need to know what the investigation is in order to determine whether or not the request that's being made is relevant. Right now, you and the respondents are kind of in the same boat. We're in the dark. We're kind of guessing because they literally told us we're not going to tell you what we have or why we think that you've done something wrong. We don't believe you when you say that you don't have responsive documents, but we're also not going to tell you what it is that we have or why we don't believe you.
Well, you cited to me 189-2-.01. And of course, there are many subsections of that that talked about exactly what type of belief, faith, rationale, reason they have to have to commence an investigation. Can you give me the subsection?
The subsection that I showed you before was on independent expenditures, and that was subsection 12, I believe. If you were talking about, I apologize, Your Honor. What rule were
you showed me two screens, and
189-2-01?
Yes.
Okay.
You showed me two screens. And the first one I managed to go and find and copy and misplace.
So 189-2-01 is about independent expenditures. I think your question, though, is going towards cause and probable cause. And let me see if I can find that for you.
I think that was section 0.04.
Yes.
Okay.
So I'm with your permission, Your Honor, I'm gonna share my screen one more time.
That one is the one I copied.
Okay, so I'm gonna share my screen one more time. The first thing you're gonna see, Your Honor, is
so that's the one that does say, I'm sorry, that's the one that says the respondent shall be notified by the commission staff in writing of the initiation of the investigation and of the basis for the finding of probable cause. That's where I was. So have you gotten that?
Yeah, I've got it up. Are you able to see it?
No. Have you received notice of, have you been notified in writing of the initiation of the proceeding and of the basis for the finding of probable cause?
We have not been notified of the basis for the finding of probable cause. We have been notified of the initiation of the investigation, but as we covered during this hearing and the last one, the commission's rationale has shifted back and forth. I'm going to show you the, I'm going to show you now 189-2-.03, and what this pertains to is what kind of notice is required when there's a complaint initiated by a third party, which is what the commission initially told us in this case, was that the Wingo complaint was the basis for the subpoena that they had sent to us. And as I said, when I responded to Mr. Amati and pointed out that the parties that they were asking about aren't mentioned in the Wingo complaint at all, then he responded and said, oh, well, we are initiating we actually were able to initiate a complaint of our own volition, which is when I then pointed him out to 189-2-.04, which requires that we be notified in writing of the initiation of the investigation and the basis for the finding of probable cause. We haven't been provided anything that explains what the probable cause is here. I believe that what the commission's position was at the prior hearing is that they don't have to tell us that yet. And they haven't told us. What we did receive was a notice of additional allegations, and that's been touched on here. That notice of additional allegation has nothing to do with any of the with NGP, the Action Fund, or Fair Count or third sector. It has to do with some other unrelated entities, and it also does not explain anything about why the commission thinks that there's any sort of probable cause. And to that end, I do think it's important, Your Honor, to note again, we've given them thousands of pages of documents. If there was something in those documents that made them say, oh, there's something wrong here, or, oh, there's something for us to be concerned about, I feel very confident that they would be able to show that to you, and they haven't. And so what this looks like is really what Ms. Young said. There is some sort of presumption on their part that if there is a communication at all, that means that there is probable cause to find potential coordination, the mere existence of communication. And as Ms. Branch ably explained, that is just not the law. That is not what the standard is. Your Honor deals with probable cause determinations, I assume, on a fairly regular basis, and I'm quite sure something more is required than to just come in and say, well, we think there might be something there, so give us all of your communications, which is essentially what they're asking here.
Is Mr. Amati's letter that you showed me an excerpt from in the record?
I believe that it is, but if it is not, I'm happy to provide it to you. But I believe it would have been one of the exhibits to our response to the motion to compel.
Okay. All right.
And we will be happy to check. And if it is not there, we'll be happy to send an email to all counsel and to Ms. Cummings after the hearing.
Okay. All right, Ms. Young, I'm going to get back to you on the same day, I promise. But how about, where's Mr. Castor?
Here, Your Honor. Can you see me?
You want to talk?
Yes, please. And I'll try to be brief. I know we've been going for a while, but I want to start by
reading over the transcript of our last hearing. I gave you the absolute shortest shrift, so I don't take too long, but I want to hear it.
Okay. Well, let me start by pushing back at one suggestion the court just made, which is that Ms. Young had committed only to the notion that the documents need to be relevant. I do think also during her presentation, she said, whatever the standard is, sure, there must be some form of reasonable cause, but it may not be anything more than that. And I bring that up because even reasonable cause is a standard that I do not think the state can meet as to fair count, because they have no reason at all for being in the investigation. I would also note that for Ms. Young's presentation is the first time I've heard characterized that the commission has now initiated an investigation into coordination involving each of the entities now before the court, because we have never, fair count has never been told that it is a target of any investigation. In fact, previous counsel told me quite explicitly, fair count was not a target of investigation. They just thought we might have relevant documents. To me, so we have not received notice of investigation, and we would certainly want to receive a statement of the probable cause for investigating fair count, because quite frankly, I don't think the state could even write that statement in good faith. I do not think they would be capable of committing to writing a basis for stating that they have probable cause for believing that fair count is involved in any form of wrongdoing. I'd also like to address what I think are a couple, frankly, sort of mischaracterizations of the record by Ms. Young's, starting with something she said at the very beginning of her presentation, which is that all the parties before this court are regulated entities by the commission. That is not true. Fair count is not a regulated entity by the commission because it does not engage in election communications or expenditures. It is not a regulated entity. And that's significant because, to me, it gets to the heart of the state's assertion that they need to look at all forms of communication, because until they look at the communications, they can't know whether there is some sort of wrongdoing. That type of argument, if applied beyond the scope of regulated entities, would apply to quite literally any entity in Georgia. They could make the exact same argument about a gas station or a toy store that does not engage electioneering communications, but we can't know that for sure until we've looked at their communications. It's also quite a remarkable assertion because toward the end of Ms. Young's presentation, she suggested that even exculpatory evidence is relevant evidence. And the example she gave of exculpatory evidence is communications that aren't electioneering communications. What that essentially boils down is that evidence that is irrelevant is relevant because it's exculpatory. In Ms. Young's characterization, literally every single communication by any entity, whether they are a regulated entity by the commission or not, is a relevant document. So every email sent by a toy store is a relevant document because if it's irrelevant, it's exculpatory. The second statement I want to address that I believe is a misrepresentation is, again, that the commission has initiated an investigation into coordination by the entities before the court. To my knowledge, there is no investigation of fair count. We've never been noticed of it, and we've in fact received the contrary representation. And if there has been investigation initiated, then it seems that the relevant standard is probable cause. I think the court has justifiably had a bit of trouble wrapping its head around what is the correct standard to apply and when to these requests, whether it's reasonable cause or probable cause or something else. Part of that problem is because the manner in which the commission has conducted itself. It seems relatively clear that if the commission had initiated an investigation through its normal channels, the standard would be probable cause because they would need to have probable cause to initiate the investigation and issue a subpoena pursuant to that investigation. Because the commission attempted not to do that is the reason why this court finds itself in a problem defining what the relevant standard is. But at least as to fair count, we would submit the relevant standard, no matter how it's defined, whether it's reasonable cause or any level of suspicion, is not met to our organizations for reasons I'll get into. The third statement that I think is a misrepresentation that is of direct relevance to fair count is that the commission has never received a statement from fair count that its predecessor, Third Sector Development, was not in operation during the election cycle. That is not accurate. If you, the affidavit that Fair Count filed by the current CEO of Fair Count, what explained that Third Sector Development was originally created in 1998, and its purpose was to build the capacity of micro and small service organizations. One of the organizations to help to create, originally embedded inside of Third Sector Development, was the New Georgia Project. That organization became incredibly successful, and it became clear by 2016, well before the gubernatorial election, that that organization should be spun out, and New Georgia Project started the process of spinning out. To do that, they needed to have some staff, and I think this is where the reference to possibly overlapping staff exists. There were some staff who were on New Georgia Project and Third Sector Development so that they had the authority to wind the organization down to comply with our IRS obligations and the like. And the statement that opposing counsel referenced that that was concluded sometime in 2017 or early 2018 is referring to the point at which New Georgia Project completed its process of spinning off into its own organization. The reason why Fair Count has not made a representation as to exactly when that was is because those aren't documents Fair Count would have. We don't know exactly when New Georgia Project completed that process because that would be handled by New Georgia Project. But counsel then went on to say that we have never represented that third sector development was not an operation during the election cycle. The very next sentence of the affidavit that we have filed with this court says, meanwhile, third sector development entered a period of dormancy during both the lead up to the 2018 general election.
1 second, Mr. Castro. Dormancy.
Dormancy, that's correct.
Right. Meanwhile, I think you said, meanwhile, third sector entered into a period of dormancy.
That's correct.
Okay.
Meanwhile, third sector development.
And she wants you to slow down in general.
Okay. Sorry.
That's okay.
I was trying to keep the pace moving, but I talk fast. Meanwhile, third sector development entered a period of dormancy during both the lead up to the 2018 general election and the election itself. Third sector development was inactive. To the best of my knowledge, it was not performing any activity during this period, did not make any communications, and for that reason, certainly could not have engaged in any electioneering communications. And for the court's background information, a number of the staff who worked for third sector development moved into other roles, including working on the lead up to the gubernatorial campaign. Third sector development was not well staffed and it essentially shut down. It did not exist. There weren't communications of any sort. After the election, when Ms. Abrams and others decided to create an organization to deal with census issues, they used that dormant structure because it had been well developed to start micro-organizations to start Fair Count. But Fair Count in its current form did not exist at all during the campaign. And third sector, its predecessor, was doing quite literally nothing during the period of the campaign. And so one of the reasons why, to Fair Count, Ms. Lewis's 1A suggestion, as you put it, of how to narrow it would be fine with Fair Count, because if it is so limited to the time of the campaign, there are literally no communications belonging to Fair Count that could be responsive to the subpoena. But in any case—
To the subpoena. Okay, Mr. Castro, let me make sure I understood one thing you said, not just sound-wise, but you said that Fair Count used the well-developed structure of third sector to start Fair Count, and then did you say it was not operative until after the election?
That's correct. Fair Count, so Fair Count as a census organization, after the election was entirely concluded, including the election being certified, any disputes as to the election. After that period, some additional Ms. Abrams worked to create some additional organizations, most famously Fair Fight, which works on election issues. Fair Count, which has no role in election issues, does not engage in electioneering, election communications, or comment on elections in any form whatsoever. Its role is to increase participation in the US Census. That's the only thing it does. That organization did not exist. That organization in its current form did not exist at all during the election cycle. What is technically true is that the existing nonprofit structure that became Fair Count was at one point, you could follow its lineage back to third sector development, but third sector development itself was also dormant during the election cycle and was not engaged in any activity during that election cycle. A final point that I think is a oversimplification or misrepresentation of how communications occur is the suggestion that any communication that could have occurred with the campaign necessarily would be electioneering communication. And I just thought it might be helpful for the court to have some examples of things that would clearly not be electioneering communications. I think that Ms. Branch has already provided the law on arguable close calls about coordination. There are also some communications that don't come anywhere near close. One example would be that the campaign manager for Ms. Abrams is friends with the CEO of Faircount. They have a longstanding personal relationship. It is entirely possible an email exists inviting one of them to the other one's birthday party. There is no question that is not electioneering communication, and it is not relevant. In addition, there may be some documents that are plainly protected by a First Amendment right. For example, it could be that the campaign manager for Abrams spoke to a donor, and the donor happened to mention to her that she was also interested in census issues. And in that scenario, the campaign manager might send an email to the CEO of Faircount saying, hey, you might want to go have dinner with that person. That is exactly in the core of the First Amendment protection, which protects expression. Disclosing that information to the state violates the First Amendment issues of the campaign, of Faircount, and of the potential donor. And importantly, the violation of expression is one that's held to the state. And so if I can take sort of the third stab at answering the protective order question, well, we would certainly support a protective order if there's going to be discovery. We would also say that First Amendment expression and association is specifically a protection against state interference. And so the act of disclosing that documents to the state, even in the presence of a protective order, still implicates First Amendment privileges.
Okay.
Yeah. And then the court doesn't have any other questions. I guess what we conclude is we would ask at a minimum that if the court decides to continue with order some discovery, that and any discovery could potentially require Faircount to produce material, that the court pushes the state to meet at least some standard, whether it be reasonable cause or probable cause, articulate to the court either in this hearing or in person or even in camera why it has some actual basis for believing that Faircount has responsive materials, because frankly, we haven't heard any. And the last point I will make about responsive materials is Ms. Young seemed to suggest that the affidavit we already have on file with court categorically stating we do not have responsive material is somehow defective because Ms. DeHart was not at Faircount during the election cycle. She was not at Third Sector. That is a true statement because nobody was working for Third Sector development during the election cycle. However, Ms. DeHart is the CEO of Faircount. She is capable of speaking to the organization. She is not speaking willy-nilly. I met with her. We took a look at what files existed in our possession and came to the conclusion there were not responsive materials. Finally, even if it were the case that she could not conclusively speak to what documents existed during that time period, for the same reason, it would be futile for this court to enter an order enforcing the subpoena, because for the very reason we can't identify responsive documents, we can't produce responsive documents. So if in theory there are some world of documents that Ms. DeHart is unaware of, those same people who've worked only for Faircount and never for Third Sector development are not going to be able to locate or produce those documents in response to a subpoena.
Okay. Now, Ms. Young, I hope you took really good notes. What we're going to do is just, the court reporter has a physical job. So we're going to take a 10-minute break, and then I'm going to come back and I'm going to hear from Ms. Young, and then we'll conclude. Okay? So 10 minutes, everybody. Thank you. I'm one court reporter shy. Give me just a second. There we go. Tell me when. All right, we're back on the record, and Ms. Young, I'll turn these proceedings over to you for rebuttal.
Okay, and I will try to be as go through this as quickly as possible, and you know, if you'll forgive me jumping around, I'll just kind of take them in order that they appear in my notes based on as they were coming up. The first thing I'd like to address is Ms. Branch cited FEC versus Christian Coalition, and I do encourage the court to read that case. That case did find that the communications at issue were not in fact coordinated, but I'd like the court to look at how they determined that, because they determined that by looking at the documents. They looked at a variety of documents. The court noted that there had been extensive discovery of documents, and the key document that was analyzed by the court in that case was produced by the RNC, which was not a target of the investigation in that case. That brings me to my second point. There's been a lot of discussion about whether people did or didn't have notice, you know, that they're the target of an investigation. That's not required, because administrative subpoenas are not limited to being issued to people who are targets of investigations. The language of the statute specifically say that it applies to witnesses. So anyone that has relevant information to an ongoing investigation can be subpoenaed by the commission. So it is not incumbent upon the commission to first send a complaint or other formal notice alleging that any of these organizations have violated the act. It's simply incumbent upon the organization to have that threshold level of relevance to the investigation.
Okay, let's take that point up, and again, put a pin in your notes here. So I think that you are telling me just then that under 21-5-6 that the commission can issue subpoenas to compel any person to appear, give sworn testimony, or produce documentary or other evidence. Correct?
That's correct. Correct.
Okay. Now, is that statutory language regulated by any rule or regulation of the commission?
Yes, and hang on one second, so I make sure I cite the right one. Give me just 1 second. Is 189. Point 189-2-.07.
Okay.
Defines.
Let me find that. Hang on. I've got that open. All right.
Further discusses administrative subpoenas in subsection 2.
Okay.
That says that if commission staff deem it appropriate in the course of an investigation or to secure witnesses or documents at a hearing, they may serve an administrative subpoena. And if a person or entity to whom an administrative subpoena has been issued objects, they are to file a motion to quash the subpoena before the commission within 10 business days. None of the parties here have done that. I would contend that that's a waiver of administrative remedies. But I think there's no credible suggestion that there's a requirement in any statute or regulation that requires the commission to notify a person, we are investigating you, before we send a subpoena.
Now, what defines an administrative subpoena versus the Code Section 21-5-6 subpoena?
Well, by nature, any subpoena issued by the commission would be administrative because it's a state agency. It's not a judicial subpoena. So therefore, you would consider that an administrative subpoena.
So all subpoenas issued by the commission are administrative?
Correct.
Okay. Wait a minute. Wait.
Well, I mean, at some point you might be in superior court or federal court and issue a subpoena through that in those proceedings, but those would be issued actually by the clerk's report and not the commission.
Okay. Well, let me just make sure I'm writing down the correct thing. All subpoena issued by the commission are administrative.
Correct.
Okay. Okay.
And going back to this notion of third-party complaints, I would caution the court to think about, the type of precedent that would be set by such a requirement. It would not be in the interest of candidates like Ms. Abrams or other candidates that may be in future elections to create a precedent by which the commission is compelled to prematurely initiate complaints. It's better for them to have the ability to gather the information first before they issue an official document formally charging somebody with a violation of the act. And I'm not certain that that's really in the best interest of politicians to, encourage early creation of documents before the commission is ready to assert that it's completed its investigation and has found probable cause.
So you think it's better for candidates to give up every piece of information in their possession, custody, or control in hopes that the commission will go away?
Well, we're not asking for every piece of information in anybody's custody or control, but I will point out that there are cases where the investigation concludes with claims being administratively dismissed by the commission because they found that there was not sufficient evidence to charge someone with a violation.
Hang on, Ms. Young, I'm sorry, the court reporter was having trouble with that. What's the last thing you heard? The investigation concludes. Can you finish your sentence?
There are cases where the investigation does conclude with the investigation being closed without charges being brought because the commission has determined that there's not sufficient probable cause to charge someone with a violation of the act. So there are definitely cases in which a candidate might very much be interested in letting the commission review responsive documents and make that conclusion before issuing a formal complaint that they would then have to address in the media. Moving to the next thing I have in my notes, there was a misstatement by Ms. Branch about a $25,000 threshold applying to independent committees. That requirement applies only to coordinated political action committees. An independent committee is subject.
Sorry, it applies only to what?
To coordinated PACs, political action committees. Independent committees are not subject to that $25,000 threshold and have to register with the commission as soon as they begin raising funds and spending money advocating for the election of a candidate or for a ballot position or other types of covered campaigning.
Okay.
Also, a lot of comments were made about the commission, basically just being curious about what people are saying to each other and who is saying what. And I wanted to emphasize, this is not a case of the commission just being nosy. In order to make these types of determinations, you have to be able to figure out what kind of organization we might be dealing with. And these communications are relevant to making that determination. Ms. Lewis had indicated that there have been thousands of documents produced, and I just wanted to remind the court that not one of those documents is responsive to our request for communications. Also, there's been a lot of
wasn't there some email, or did that come from somebody else? Mr. Fuller talked about one, I think.
I don't know what he mentioned, but there has not been any production of communications from anybody in this case. I just wanted to emphasize that. I also wanted to emphasize there's a lot of discussion of this is not what the Wingo complaint was about. OCGA 2157 makes it very clear the commission is not stuck with a third-party complaint. They are not bound by, a citizen's description of a violation of the act. They're bound to begin investigating it. They're entitled to peel back layers of the onion. And if they find other things not mentioned in a complaint, they're entitled to pursue that. And that is very expressly stated within that statute itself. And that's exactly what is happening here.
Can I stop you, Ms. Young, and go back to one thing on this rule 189.2 189-2-.07. So was the subpoena sent to the Abrams campaign an administrative subpoena?
Yes.
Okay. And then that's the case with the other subpoenas before the court?
That's correct.
Okay. So all of these subpoenas were administrative subpoenas?
Correct. The next thing that I wanted to address is
Can I just finish just this one thing? So as I understood your earlier assertion, and it, bless your heart, it's been a long time ago, that the only tie or the only standard in issuing an administrative subpoena or any subpoena prior to a case being contested is relevance. Do you still maintain that the subpoena has to be relevant?
I believe that's generally correct. I did want to correct one thing that I had said about the applicability of the Civil Practice Act, because there are two areas of authority that grant the commission the subpoena power. One is within the Ethics and Government Act and the commission's regulations themselves, but they also have that authority under the APA, and 501313B does actually reference 9/11/37. You know, that when they don't comply with the subpoena, the commission can come into court and has the power to file the motion to compel as if it was a 9/11/37 case. You know, and whether that changes the express standard of the act or not, I don't think the court has ever decided. But I would say that, you know, that standard would be reasonably calculated to lead to admissible evidence. And, you know, communications is defined by the statutes and by similar cases that have been decided under FEC rules. You know, you have to look at the communications between the parties and the subject matter of the communications. That's absolutely relevant and reasonably calculated to lead to admissible evidence.
So the Rule 26 standard does apply.
Well, so I think that the subpoena power granted under the Ethics and Government Act is somewhat broader than the 501313 APA subpoena power. But there's no case law on that. And I'd be happy to, you know, to argue that we do meet the 9/11/37 standards, and therefore, you know, don't think it's necessary to reach that question. But the statute and its regulations do suggest that it is a more discretionary standard for the agency, and a standard of relevance in the discretion of the commission.
Okay, now let me, I'm sorry to keep such a small mind on this, but going back to Rule 189-2-.07, in the middle of the paragraph, I guess it's 2A. If it is deemed appropriate by commission staff in the course of an investigation or to secure witnesses or documents at a hearing before or on behalf of the commission, an administrative subpoena may be served to obtain relevant documents or the attendance of a witness. It goes on to say in subsection B, if a person or entity to whom an administrative subpoena has issued objects to the subpoena, such person shall file before the commission a motion to quash the subpoena. Now, you came to the Superior Court before before the commission could rule on, I mean, I understand they didn't file a motion.
Nobody filed one.
Excuse me?
Nobody filed a motion. They just didn't give us the documents.
Yeah, but is that your remedy? Well, the Court of Appeals has already answered that. Go ahead.
Well, I actually think that, you know, the answer to that question is they, have waived their right to object because they failed to exhaust administrative remedies, although that would be more typically.
Wait a minute now.
Well,
I got hung on that.
That would apply more clearly in a case in which they filed the Superior Court motion themselves. But I do think it's a question that the court could consider whether or not they can simply not file the motion to quash and then raise these objections before the court.
Okay.
I also wanted to talk about the burden because, the parties have all kind of taken the position that and have tried to kind of convince the court that it is the agency's burden to demonstrate that the subpoena is valid, when in fact the opposite is true. And I'd like to cite a case that may not be in our brief, but the case is United States versus Morgan Salt Company, 338 US 632.
Are you saying Morton Salt?
Mm-hmm.
Okay.
And
338 US 63?
632.
632. Okay, thank you.
And that sets forth, the basic rule that when an agency subpoenas documents, there are only two issues the court traditionally looks at, and that's whether the demand is within the scope of the authority and whether the demand is sufficiently precise and relevant, and that the burden of showing the unreasonableness of the request is on the subpoenaed party. That burden is not easily met when the agency inquiry is pursuant to a lawful purpose and the requested documents are relevant to that purpose. Broadness alone is not sufficient justification to refuse enforcement of a subpoena. And thus courts have refused to modify investigative subpoenas unless compliance threatens to unduly disrupt or seriously hinder normal operations of a business. Courts have gone on following Morton Salt to talk about First Amendment challenges. And they say that you can raise the First Amendment challenge under the Morton Salt framework. But again, that burden is on the complaining party to establish both the existence of the privilege and the applicability here, and that the privilege is sufficient to override the state's compelling interest. There are lots of cases talking about the reasons for government's interest in these disclosure obligations, the requirements of registration, and campaign limitations to the extent that those are campaign contribution limitations. Obviously, the three leading cases in that area are Buckley versus Vallejo, McConnell versus FEC, and Citizens United.
Wait. You're losing us a little bit.
Sure.
You started citing cases. I'm sorry. Could you do that again?
So Citizens United is one of the leading cases, the most recent, seminal case, following on after Buckley versus Vallejo and McConnell versus FEC. All of those talk about the state's interests in regulating these disclosures and why they're important. Buckley specifically talks about the importance of the state's interest in getting the information needed to figure out if there's been a violation. And the state does have a strong interest in getting that. The Ethics in Government Act is toothless if the commission cannot obtain the information it needs to determine whether or not there's been a violation. For a First Amendment privilege to override that interest, the only cases that have recognized that have been where there's a significant privacy interest in things such as donor information, which the commission is not seeking at this point, and where the government's need for that information is correspondingly weak. We have a strong need for the information here, and we don't have a clearly articulated argument as to why these communications would be subject to any type of privacy concern or privilege at all. The concept of narrowing the request, and I do appreciate finally seeing something specific in terms of a proposal on this. The problem with the proposal is that it would allow the parties that may or may not be targets of the investigation or may just be witnesses to an investigation to make the ultimate decision of the issue of fact and the merits of the inquiry. You know, we do, by allowing them to determine whether or not this is a document that reflects coordination or not. That's not what happened in the Christian Coalition case. You know, the Christian Coalition case required them to produce the document, and the court was the ultimate arbiter of whether or not it constituted communication. Courts have never allowed parties responding to document requests and subpoenas to, without any oversight whatsoever, make a determination of whether or not a document does or does not prove an ultimate issue of fact in a case. And this court should not allow any limitations like that now. The court also mentioned open records and special masters. And in terms of open records, I wanted to make the court aware that it is our position that the open records would not allow us to produce any documents that we receive in response to this subpoena until all proceedings have been concluded. We would have no objection with the court entering a protective order that either corresponds with that and matches the Open Record Act's exemption for until the proceedings are concluded, or even beyond that if the court thinks that's necessary. With regard to special master, we would certainly prefer that over the situation that we have been experiencing to date. My only response to that is cases that involve special masters usually begin with a sufficient showing of a privacy interest that needs to be protected. I don't think that's been shown here, but as a practical matter, we would certainly prefer that to prolonged proceedings and appeals. You know, if it takes going through a layer of review by special master to get us the documents more in a more timely fashion, we would not necessarily have any objection to that. With regard to the question about payment of expenses, of course, if there's any reasonable expenses needed in terms of gathering, copying, producing the documents, we'd be more than willing to consider that. A question was raised about Nikema Williams, which I did not remember to address in my main argument. The reason for the request for communications with regard to—
Hang on. With regard to Nikema Williams, what's the last part you heard? Nikema Williams, could you just pick up where you said the name Nikema Williams?
Mm-hmm. Yes, the reason for the commission seeking communications between the Abrams campaign and Ms. Williams is because Ms. Williams was the head of a registered independent committee called Care in Action. And I do believe that Mr. Amati did send a letter specifically including that organization in one of the notice of additional allegations earlier in the case. But in any event, Care in Action is a registered independent committee. The commission would like to examine—
Care in Action?
Care in Action.
Care in Action.
And Ms. Williams was identified because she was, I believe, the CEO of Care in Action. In terms of fair count, I did not mean if I stated that they were directly a target of the investigation, I did not mean to suggest that. I do recognize that I probably was lumping everyone together, but I did not intend to suggest that the commission had taken a position that specifically fair count was a target of the investigation. They are, at the very least, a material witness to the investigation because up until early 2019, they were New Georgia Project. You know, it was not until early 2019, after the 2018 election, that they completed that winding down process. So communications involving New Georgia Project and New Georgia Project Action Fund may very well have been taking place under the umbrella of third sector development during the relevant time period. So that's the purpose of that subpoena. And one other thing, in terms of limiting personnel, I think the court was correct to be wary of specifying on the front end which personnel do or do not have responsive information. Receptionists could very easily have participated, by setting up appointments or, confirming appointments with people, things like that. So just because somebody doesn't have necessarily an impressive title or isn't, formally authorized to bind a corporation or act on their behalf does not mean that they would not have any relevant documents. So we would ask that the court not place such a limitation on the subpoena. And I think this will be my final point. Ms. Just Lewis was correct in talking about, and very candid about the fact that as to the campaign is, does not have the same privacy rights that other people might have. The law is very clear. The public's entitled to know who supports a candidate and, who's spending money to promote a candidate. And just as Ms. Abrams is not allowed to conceal her direct donors, and that's why she's required to file these reports, they're also not allowed to conceal any in-kind donors, and the donors are not allowed to keep those contributions secret themselves. And that's why for coordinated expenditures, you have that rule of looking into communications. And for independent committees, you have the rules of registration and identification of donors and expenses, because the public has a right to know who is spending money to promote a candidate. And, the heart of these regulations is to prohibit the public from being kept in the dark by the use of corporate formalities and separations. And that's why the commission has the job that it has to do in this case. So we would ask that the court enter an order requiring each of these parties to produce any documents that are responsive to the subpoena. Thanks.
The following things are going to happen. I am going to make a decision, and regretfully not one right now, for which my staff attorney will be furious. I'm going to make a decision. In all likelihood, we will inform you informally of that decision, much as I would be doing right now, and ask one of you to prepare the order. Less likely is that I will prepare an order. But we will make a decision pretty soon and let you know. You're all so smart. And I can't thank you enough for everybody participating today. And thank you again. Before